Thank you. Good morning. My name is Janet Silvera. I'm president of the Montego Bay Chamber of Commerce and Industry. And I wish to thank Dunncox, attorneys at law, and the UWI Western Jamaica campus for facilitating this, our third in a series of webinars. We decided that we would leave the best for last, a topic that is very, very important to the business community, to Jamaicans on a whole. Those of you who do business will want to know more about this. As the treatment of the use of personal data begin to change globally, Jamaica has taken on its own strides by tabling a bill called the Data Protection Act. The Data Protection Bill imposes several obligations on data controllers and provides guidelines on how personal data should be collected, processed, stored, used, and disclosed. This bill was passed by the Senate on June 12th. That's only a month ago. And as it becomes more imminent, it is pertinent for business owners to understand what will be required of them when this bill comes into effect. Our presenters this morning will seek to outline and expound on the data protection standards set out in the Data Protection Bill, while they enlighten us on the rights and obligations under the Data Protection Act. Ladies and gentlemen, those of you who are watching, our speakers this morning are Kelly A. Aiken, who is an associate of Dunncox, and Courtney A. Bailey, managing partner. Kelly Aiken joined the firm's corporate and commercial department in 2016. Kelly's practice focuses on conveyancing and commercial transactions, competition law, franchising agreements, preparing and reviewing commercial contracts, mergers and acquisitions, obtaining work permits and other immigration issues, transfer pricing, protection of trademarks, and copyright and corporate due diligence, as well as corporate secretarial conveyance matters. Kelly obtained her Bachelor of Laws degree from the University of the West Indies and her legal education certificate from the Norman Manley Law School. She was called to the Jamaican bar in January 2016. Our next speaker, Courtney A. Bailey, is a member of the firm's corporate and commercial department and has been a partner at Dunncox since 2006. In his commercial practice, he has been involved in and advised on complex commercial transactions involving loan and security documentation, energy project financing, mergers and acquisitions, and corporate financing by private placement. Courtney has practiced extensively in civil litigation with primary experience in commercial litigation. His commercial litigation experience includes acting on behalf of clients in claims in relation to banking and finance, insurance and reinsurance, commercial arbitration, and intellectual property. He has appeared both as counsel and instructing attorney, instructing Queen's Counsel in complex litigation matters before the Supreme Court and the Court of Appeal of Jamaica. He has gone as far as the Privy Council in the UK. Ladies and gentlemen, we have two of the most important assets at Dunncox speaking to you this morning on a subject matter that is extremely critical to Jamaica. With the Data Protection Act just being passed, I can understand that you're going to have a lot of questions after they're through. So we invite you to put in your questions. We will have 30 minutes after their presentation to respond to your questions. We also have a survey that you can fill out at the end of the presentation. Ladies and gentlemen, I present to you the two speakers. Thank you.
and good morning to everyone who's joined us online for this webinar on the Data Protection Act 2020. Thank you for taking the time to be with us. We know that you could be using your time to do other things. I want to start by saying that Dunncox is pleased this morning to partner with the Montego Bay Chamber of Commerce and with the UWI Western Jamaica campus in presenting this series of webinars. Our participation in this series reflects our commitment to the development of Montego Bay and Western Jamaica and our continued investment in its community, as is evidenced by the fact that we have boots on the ground, as they would say. We have a physical office in Montego Bay. By this series of seminars, we've sought to play our part in assisting businesses in Jamaica in navigating the novel circumstances we've all found ourselves in due to COVID-19. COVID-19 has accelerated the movement of various kinds of businesses online and the trend towards remote work. This, of course, raises issues in relation to the protection of data. And so in this final webinar, we consider the Data Protection Act, which has been recently approved by both Houses of Parliament and now only awaits the signature of the Governor General and the publication by Gazette of the appointed day for it to come into operation as law in Jamaica. I want to say preliminarily that, strictly speaking, it is not yet an act, and yet for sake of convenience and ease of reference, during the course of our presentation, we will refer to the legislation as the Data Protection Act. I want to start with an image as our first slide. And I want to use this to begin by suggesting to you that there is more to the Data Protection Act than meets the eye. This legislation represents a sea change in how data will be regarded and treated going forward. In 2011, the Jamaican Constitution was amended to enshrine as a fundamental right the right to privacy and privacy of communication. This reflects a worldwide trend towards recognizing, as we move further into the information age, recognizing the rights of individuals in relation to their personal data. One manifestation of this was the GDPR, and you see that acronym there on the slide. That refers to the General Data Protection Regulations, which came into force in the EU in 2018, and it roughly corresponds to our Data Protection Act. In trying to comply with its treaty obligations, Jamaica has made, as Janet said, strides in passing the Data Protection Act. This act has significant implications for business operators, and I think it's going to take some time for us to get our mind around it. And I think the point of this cartoon is quite simply that we underestimate the magnitude and significance of data protection legislation to our own detriment and at the risk of titanic catastrophe, pun intended. We want in this presentation to begin revealing what's beneath the surface of this legislation so that we can all begin to take measures to avoid some of the possible challenges. The presentation will be in two parts. My colleague, Kelly Aiken, will first give an overview of the legislation by exploring the rights and obligations under the Data Protection Act. That's sort of the wide-angle shot. And then we're going to narrow the focus and zoom in on the data protection standards. And I will present on understanding the data protection standards. And so let's begin, and allow me now to invite my colleague Kelly Aiken to the lectern, and she's going to guide us first through the rights and obligations under the Data Protection Act. I give you Kelly Aiken.
Thank you, Courtney. Good morning, everyone. As Courtney said, I will be looking at an overview of the key points that businesses and individuals should be aware of as it relates to this new piece of legislation, the Data Protection Act. The world we live in today, most, if not all the processes, the transactions that we carry out, is carried out drastically in the electronic sphere. You know, digital, it has a very large digital component. As Courtney mentioned, in 2020, this is particularly important with coronavirus COVID-19, which has created a push towards concluding these transactions electronically. So the question is, what is data protection? It is the security of the data that individuals give to companies. It is the measures that these companies put in place to ensure the safety and the confidentiality of the information that they receive. It is ensuring that individuals understand what personal data is being processed by these companies and for what purposes. Now, why is it important to individuals and companies alike? The Data Protection Act gives rights to individuals as it relates to their personal data being processed by various entities. And it is important for people to be aware of what these rights are. Equally important for businesses is that they understand that when they process personal data, they need to be aware of these individual rights that data subjects have, as well as they need to be aware of the manner and the way that they treat this personal data. So, who does the Data Protection Act apply to? It applies to, 1, data controllers. This includes companies, public authorities, persons that determine how personal data will be processed. The Data Protection Act, the DPA, speaks to data controllers' obligations to be registered with the Information Commission, to comply with standards outlined in the legislation, and in some cases, appoint a data protection officer within their organization. The data controllers may also face penalties for breaching provisions of the Data Protection Act. The Act also applies to data processors. Now, these are persons other than the data controller's employees who processes data for the data controllers. Now, this could be an external marketing company, for example, or an IT company, a website host, a variety of other parties. And last but not least, data subjects. The Data Protection Act applies to data subjects. These are individuals who are the subject of personal data that is being processed by data controllers. They may be named or otherwise identifiable, considering all means likely to be used to identify that individual. Now, we've spoken about who it applies to. Let's look at what type of data is covered by the Data Protection Act. The DPA speaks to personal data as well as sensitive personal data. Personal data is information, however stored, whether paper-based or in an electronic form, that relates to a living individual or, interestingly, an individual who has been deceased for less than 30 years. Sensitive personal data is a subset of personal data, it includes information such as genetic material, biometric data, whether a person is a member of a trade union, someone's sex life, the physical or mental health, racial or social origins of an individual. Now, the DPA makes a distinction between these two types of data because as it relates to the data protection standards, there are different ways that each of these types of data is treated. So it's important for any data controller who processes information that falls in either category to pay close attention to the operation of this act. So let's look at what processing personal data entails. Now, any business or public authority that processes personal data is likely to be considered a data controller under the DPA. And so they will therefore need to comply with the standards set out. But what does processing really entail? Now, processing or to process is defined fairly broadly under the DPA. And for that reason, I wanted to put the scope of activities that is considered under the Data Protection Act, and we're going to go through all of them. So, processing includes obtaining or recording or storing the information or personal data, carrying out any operation or set of operations on the information or data, including organization, adaptation, alteration of the information or data, retrieving, consulting, or using the information or data, disclosing the information or data by transmitting, disseminating, or otherwise making it available, or aligning, combining, blocking, erasing, or destroying the information or data, or rendering the data anonymous. Now, that's a lot. Be very honest, like I said, it's a very wide scope, and so it's important that data controllers understand that any one of these activities is considered processing under the DPA, and therefore they may be caught under sections that deal with the standards of processing data. As with everything, there are exceptions to every rule. The Data Protection Act sets out some exemptions. These are types of personal data that would be exempt from the data protection standards as well as disclosure requirements. The first important example would be an exemption from the compliance of the DPA standards and the disclosure requirements by the Minister of National Security in the interest of national security. Also, where personal data is collected for the investigation of any crime or assessment of tax, this data may, in some circumstances, be exempt from the DPA standards as well as disclosure requirements. Another one would be the personal data that is obtained for the discharge of any function by a regulator. This information, they would be exempt from disclosure to data subject requirements. Information that is disclosed to a data controller, where that data controller is obliged to make that information public under any enactment, would also be exempt from non-disclosure requirements. So that means that where there are certain rights set out in the DPA that would require non-disclosure of this information, if that data controller is required by any enactment of law to make that information public, this information would be exempt from non-disclosure requirements. And of course, data that is required for the purposes of avoiding an infringement of the privileges of either House of Parliament. So let's look at the rights of individuals. Now, this is important not just for individuals, citizens of Jamaica, but this is also important for companies, businesses that deal with these individuals, because it is important for each company to understand the rights of their customers, their employees, and how to treat with those rights. Individual rights are set out at Section 6 of the Data Protection Act, and it includes that the data subject should be informed whether their personal data is being processed by a data controller. It allows data subjects to get a description of the personal data that is being processed. That includes where the data is being processed, being given a description of the personal data, the purposes for which it is being processed, as well as the recipients to whom that data may be disclosed by the data controller. Data subjects have the right to know the source of that personal data that the data controller has. The data subject may request that information is transmitted to another data controller. The Act specifically says that if possible, that information should be transmitted in a machine-readable format, as well as where data is being processed by automatic means for the purpose of evaluating a data subject, for example, to determine the creditworthiness of an individual or performance at work, for example. The data subject has the right to be informed of the logic used in that decision making. So a simple example would be if a website has a portal that allows you to determine whether or not someone is allowed to get a line of credit. If this is an automatic process and this person is approved or denied, they have the right, that is, the individual has the right to go to the data controller and request to understand how that logic, how that decision came about. The data subject also has the right to prevent processing of personal data in certain circumstances. These circumstances would include situations where processing would cause substantial distress or harm to that individual, where there is incomplete or irrelevant personal data, where processing of such data is prohibited by law. And this is important for companies to understand, because once the data subject gives the company or the business notice that they would like to prevent their personal data from being processed, their companies will have to go through their own processes internally to ensure that this right is not infringed. And finally, the data subject has the right to request that the data controller rectifies any inaccuracy in any personal data. Now, direct marketing, it's a little bit of a hybrid as it relates to rights. I think that it covers individuals' rights as well as it informs companies certain obligations that they will have under the Act. So, Section 10 of the DPA prohibits the processing of personal data for the purpose of direct marketing, except where it is done in accordance with the Act. Now, what is direct marketing? Direct marketing means where a data subject is contacted for the purpose of promoting your business or your goods and services, or for requesting a donation of any kind. I've included this slide to give some context to what direct marketing is and the types of methods of communication used by businesses, companies, data controllers to connect with data subjects. Now, a lot of companies use direct marketing to promote their business through, over the years, telemarketing, but more recently through things like sponsored ads on social media platforms or banner ads on websites, emails, a variety of different ways. Section 10 of the Data Protection Act, importantly, does not seek to stop direct marketing. That's very important. It doesn't seek to stop it. What it does, however, is it creates focus for the companies to understand that the provision, how it is that they obtained the personal information of these data subjects. So for example, how is it that company A knows that Susan would like to buy a belt and then sends Susan an email saying, hey, we have a sale on belts? The DPA seeks to restrict direct marketing to circumstances where data subjects consent to such marketing. So the definition of consent under the DPA, it has a couple components. Consent means any informed, specific, unequivocal, freely given expression of will. So the first component of that definition is informed. This means that at the time that the individual consents to the processing of their data, that is when the individual consents to direct marketing, that they're told at that time how the personal data will be processed, the purpose for which it is being processed, and the class of persons to whom the personal data may be transferred. Secondly, consent must be freely given. Now, consent is not freely given if it is that an individual is required to give that consent to direct marketing for the purpose or as a condition of acquiring goods or services from a company. Importantly, an individual may withdraw their consent at any time. That is the consent to direct marketing. I would point out here that businesses should be mindful of their current marketing practices and do an assessment to determine whether or not these practices would be in compliance with the Data Protection Act and may have to make adjustments accordingly. So let's turn to data controllers. I'm going to take a brief look at the obligations that are set out in the Act for data controllers. We're going to take a look at some of the offenses, if there is a breach, and in those cases, what the penalties may be. The first obligation for data controllers is that they need to be registered with the Information Commission. Now, the Information Commission is the authority established by the DPA to oversee compliance with the Act. So if it's registration of data controllers, whether it's receiving complaints, sending out notices for breaches, various other functions. The second obligation that's important to point out is that in certain circumstances, data controllers will be required to appoint data protection officers. Now, these circumstances are where the data controller is a public authority, where the data controller processes sensitive personal data, and where the data controller processes large scale, so processes on a large scale. The data controller must comply with all the standards set out in the DPA. Now, there's 8 standards, and Courtney's going to be touching on that, so I'll give it over to him in a second. But an obligation for the data controllers under this Act is to comply with those standards. So, before I hand over to Courtney, it's important to understand that if you do breach any of these obligations, there are certain consequences. For example, if a data controller is not registered with the Information Commissioner, but processes personal data in any event, there is a penalty up to $2 million or 6 months in prison. As I mentioned, the data protection standards, a data controller, if they do not comply with these standards, they may face a fine up to $2 million or 7 years in prison. Now, notwithstanding those 2 points, if a company breaches the Data Protection Act, they may be liable to a fine not exceeding 4% of the annual gross worldwide turnover of that company. Now, in addition to the company being fined, any officer of the company, in the event that they had consented to this breach of the DPA or the breach was as a result of their negligence, that individual, that officer of the company shall also be liable as well as the company. So the company could be looking at a fine as well as the officer themselves looking at a fine as well. Now, companies should also note that in addition to these fines and the penalties that I've just stated, that there is still civil liability under the Act. If a data subject is aggrieved by any breach that is carried out by the company, they still may bring action, a civil claim. So, now that I've set out the framework, the rights, the obligations, and I've taken a brief look at the penalties associated with a breach of this legislation, I'm going to now hand over to Courtney, who is going to dig deeper into the data protection standards.
Thank you, Kelly, for getting our attention by talking about offenses and fines and lawsuits. I'm sure you are with us at this point in time. All right. So I'm now going to talk about understanding the data protection standards. And I want to say that a significant feature of the Data Protection Act is the establishment of 8 data protection standards. This part of the presentation aims to decode these standards into everyday language so that business operators can understand what is expected of them. A good place to begin would be to try to understand what we mean by the term data protection standards. And so let's begin with the definition in the Act. Section 2 of the Data Protection Act says data protection standards means the data protection standards as set out in sections 22 to 31, and reference any of those standards by number means the standard as numbered in any of those sections. This is why you need lawyers. The definition is clearly a circular one. I don't know why lawyers tend to write in this way. But essentially what we can understand from it is that data protection standards are created by sections 22 to 31 of the DPA. So when we refer to data protection standards, we're talking about some standards that the Act creates that data controllers have got to ensure that they abide by. There are 8 data protection standards, and each of which seek to ensure that personal data is 1, processed fairly and lawfully, 2, obtained for specified and lawful purposes, 3, adequate, relevant, and limited, 4, that the data is accurate and up to date, 5, that it is kept for no longer than necessary and that it is disposed of in keeping with regulations, 6, that the data is processed in accordance with rights of data subjects, that it is secured by appropriate technical and organizational measures and timely notification, and finally, not transferred to a country not having adequate data protection standards. So each of these are the 8 data protection standards, and they are named consecutively as the numbers beside indicate. Okay, so why should we focus on data protection standards? There are about 77 sections in the Act, and of necessity, Kelly's presentation was very broad. But we've chosen if we were to focus in on one thing this morning, we've chosen to focus in on the data protection standards. Because if nothing else that you leave this presentation with today, our hope is you will understand what each of these standards are. Why? I think that's because the Act imposes an obligation on data controllers to comply with the standards. Section 21 of the Act says that data controllers must comply with data protection standards in relation to all personal data for which it is the data controller. But it goes beyond that, as Kelly mentioned, by making it an offense to process personal data in contravention of any of the data protection standards. And then it goes further to say that contravention of the standards and security breaches of personal data must be reported to the Information Commissioner, who's an officer that has to be established under the Act, and must also be notified to data subjects within 72 hours. And then it says that failing to report is an offense. Now, once we start talking about offenses, I'm sure, again, we have your attention. And I'm sort of going over this because I know this is an area of interest that we have, but I think it sharpens the focus on why we have to pay attention to this legislation. So, as relates to data protection standards, in addition to what Kelly mentioned in terms of the wider offenses, there are, in fact, specific offenses for simply breaching any of those 8 standards that I put up on that previous slide, or for failing to report breaches of the standards to the commissioner or to notify data subjects that there has been a breach. The fines, in a parish court, if you're convicted of breaching the data protection standards in the parish court, it's a fine not exceeding 2 million Jamaican dollars, or prison for a term not exceeding 2 years. If you're convicted in the circuit court, it simply says fine. That does not mean that the fine is less than 2 million. That fine is at large. And you could face a prison term that would not exceed 7 years. In addition to that, as Kelly mentioned, there is what I would like to call the nuclear option, which is that 4% of your annual gross worldwide turnover for the preceding year of assessment in accordance with the Income Tax Act. And then on top of all of this, if the government doesn't get you, data subjects who suffer a breach are entitled to bring lawsuits against you. So this the Act, therefore, requires our attention. I want to point out that there are some transitional provisions. Section 76 of the Act says that a data controller shall take all necessary measures to ensure compliance with the provisions of this Act, and in particular the data protection standards on or before the expiration of a period of 2 years from the earliest day appointed under Section 1. What's that appointment date? That's the date that the minister is going to notify by gazette that the Act comes into operation. the earliest date that it comes into operation, or any section of it comes into operation. And so in essence, what this means is that from that date, everybody has 2 years to get all their ducks in a row. But the Act is saying that each data controller has got to ensure that it complies with the provisions of the Act, but then it focuses us. It says, in particular, the data protection standards, which is why I think it's so important for us to familiarize ourselves with the standards and let that be our starting place for getting ready for when the Act comes into operation. Now, subsection 2 of section 76 says, no proceedings under this Act may be taken against a data controller in respect of any processing of personal data done in good faith during the period referred to in subsection 1. So in other words, during that 2-year period, they can't bring any proceedings against data controllers. But notice it says, in respect of any processing done in good faith. So if even before that 2-year period, if they were to find that you process personal data in a way that is not considered to have been done in good faith, you could face proceedings being brought against you. And so I think it's important that we actually make sure we don't wait until the 2 years to get ourselves in compliance. So let's start with the different standards. The first standard is that personal data shall be processed fairly and lawfully. That can be broken down into 2 components, very simply. Fairly means the data is legitimately obtained and the data subject is informed about its processing. Lawfully simply means that there is a legal basis for the processing. So let's talk a little bit about fairly, if we can drill down some more. Section 22(2) of the Act says that in determining for the purposes of this section whether personal data are processed fairly, regard shall be had to the method by which the data are obtained, including in particular whether any person from whom they are obtained is deceived or misled as to the purpose or purposes for which they are to be processed. In essence, this is saying that in determining whether someone has processed data fairly, you're going to look at how they got the data. And you're going to look to see whether they deceived, misled someone in order to get the data. They used it for some other purpose than what they said. So for example, if a data controller elicits personal data on the basis that will be needed or will be used to verify identity, or to assist in know your customer requirements, but then turns around and in fact uses that information to build a profile for use in targeting certain services, this would amount to a breach of the standard. Section 22(3) says data is deemed to be obtained fairly if the information that is obtained comes from a person that is authorized to supply it, or secondly, a person who is required by law or some international treaty obligation that Jamaica has to supply it, or for the purposes of determining suitability for honors, scholarships, prizes, bursaries, or awards. But then in 22(4), it tells us that if we don't fall in that earlier category there that we just saw in the 22(3), that the data will not be considered to have been processed fairly unless, 1, it's been obtained directly from the data subject or someone who's authorized in writing to provide it by either the subject or the commissioner. And secondly, the data controller ensures the data subject is provided with certain information. And in other words, they must have told the subject what is their identity. I'm processing your data. The purposes for which you're going to process the data, what's the identity of the third party to whom the data disclosure is likely to be given of the data, and finally, what is expected period of retention of the personal data. So let's talk about lawfully. 7 conditions for lawful processing of personal data under section 23(1). And essentially, unless you can say that you fall into one of these categories, you would be processing data illegally. 1, the data subject must consent. 2, the data subject has published the personal data. In other words, they put it up on Facebook or Instagram or tweeted it or something, and it's at large in the world. They can't come and say, how come you're processing it? Well, you gave it up to the world. As well, if processing is necessary for the performance of the data subject's contract. So let's say the data subject is buying a piece of land, and you need TRN in order to conclude that transaction. Clearly, obtaining that TRN would be lawful. Or for compliance to data subject's legal obligations. For example, know your client or anti-money laundering requirements, or if you have employees taking their NIS and TRN number in order to pay income tax for them. And then there are some others to protect the data subject's vital interests, which simply means it's a life and death situation. Your doctor has a right to find out your medical history or your height and your blood type, etc., in order to save your life. It's also necessary for administration of justice, carrying out legislative or public functions. And finally, for purposes of pursuing legitimate interests of the data controller or third party. Consent. I won't spend long here. Kelly already, I think, gave an excellent description of consent. The point I want to make is don't think that consent is the easiest one. Because the consent has to be informed. In other words, you must tell people what you're going to do. But as well, you can't get the information on the basis that I am not going to provide this service unless you provide this data, unless the data that you're asking for is reasonable in the circumstances. For example, if I'm buying a shirt online and they ask me my shirt size, that I think is reasonable. If they were to ask me for my TRN or overseas my social security number, no, that would be unreasonable. I think you get the idea. Kelly as well also spoke about the different conditions she spoke about what sensitive personal data is. And the point I want to make here is, whereas you saw the 7 conditions for processing personal data, I want us to understand that if you're processing sensitive personal data, and the components of that are here up on this slide, anything of this sensitive nature, there is a different standard for you to say that you're lawfully doing so. In other words, sensitive data is a subset of personal data. And so you have to come up to a higher standard, and there are 11 different conditions for processing that type of data. So if you're dealing with any kind of information like this, then you need to apprise yourself of what these 11 conditions are. I won't take the time to do that now. If you have questions for me, I could address that in the Q&A. The second standard is that personal data should be obtained only for one or more specified and lawful purposes, and shall not be used, shall not be processed in any manner incompatible with those purposes. This standard seeks to ensure that personal data is only processed in accordance with the purposes specified, which must be lawful. We talked about lawful just a moment ago. So to comply with these standards, data controllers must specify upfront what personal data will be used for, and limit processing to only what is necessary to meet that purpose. So generally, you're going to provide this type of information in privacy notices, in terms and conditions and consent forms when you tell people, when you're taking information, I'm going to use it for X. These need to be clear and unambiguous about the extent of the processing that's going to take place. And the actual processing should be within the bounds of that description. If you go outside of what you said that you're using the data for, you would have breached. So for example, a supermarket would breach the second standard if it collected customer information on the basis of offering reward points as part of a loyalty program, but also use that information for an affiliate to make targeted offers to customers based on spending patterns. The third standard, personal data shall be adequate, relevant, and limited to what is necessary for the purposes for which it is processed. This standard seeks to prevent data controllers from holding more than strictly required. We have a way, when we're trying to get information to run businesses, we think, let's ask as much as we can. Get the middle name. Get the mother's maiden name. Get the TRN. Get everything. You never know if you may need it or not. And yet, that is a problem because this standard now says you're only to get what you need adequate. It must be sufficient to meet the purposes for which you're going to process. Secondly, it must be relevant. It must be directly related to what you said you're going to process the information for. And finally, it must be limited. It should not exceed what is absolutely required to satisfy the specified purposes for which data is to be processed. So you have to strike a balance between obtaining enough information to ensure that the data processing results in correct outcomes, whilst at the same time not obtaining more information about the data than is needed. Many firms will need to re-examine standard forms which they presently use to collect personal data to see if all the information requested is actually needed to satisfy the purposes specified for collecting the data. Let's say, for example, a recruitment agency that places workers in a variety of jobs may send workers a general questionnaire. If the questionnaire includes specific health questions that are only relevant to manual jobs, it would be considered irrelevant and excessive to administer these questions to persons applying only for office jobs. I hope you get the point. The fourth standard is that personal data, I'm sorry, I think somehow I jumped past it. Yeah. The fourth standard is that personal data shall be accurate and where necessary, kept up to date. And this standard protects against risks from inaccurate information such as identity theft, which can result from delivery of sensitive documents to an old or inaccurate address. It ensures that any automated decisions, like Kelly mentioned earlier, that are made in relation to data subjects are based on accurate data. So you want to ensure that you keep your data up to date. One of my banks sends me, I've noticed recently, these emails with the caption, "Is your information current?" And they invite you to click on to a link and then to update their database with your current information. I think that's the direction in which we need to be going in seeking to update and keep the information current. Of course, you have to make sure that you send it to the correct email address. But that standard imposes an obligation to ensure that you keep information accurate. There are actually cases where companies have been sued because people's personal information have been sent to persons who shouldn't get it, say at an incorrect or old address, and that has been considered a breach of the fourth standard. The fifth standard is that personal data should be kept for no longer than necessary to accomplish the purpose for processing and should be disposed of in accordance with regulations. This means that data controllers must determine whether they still require personal data that they have collected, and if not, they must dispose of it. Since the definition of processing in the Act, as Kelly mentioned earlier, includes storing, just having the information and not processing it by doing anything more than just keeping it in your possession amounts to processing until it is deleted. In simple terms, if you no longer need the data, get rid of it. You should have a defined purpose for the data, why you collect it, and so once you've got to that stage of using it, you need to find a way of disposing of it in accordance with the regulations. The regulations have not yet been promulgated, but eventually they will specify the standards by which the data needs to be deleted. Wherever possible, it will be preferable to simply delete or destroy all personal data immediately following processing, as this will save having to implement additional measures. And then, of course, you have to think about what maximum and minimum time periods you need to keep the data for. We could talk about that some more in the Q&A. The sixth standard, personal data shall be processed in accordance with data subjects' rights. And Kelly went through the rights of the data subjects when she mentioned some of them in section 6. The rights are actually found in sections 5 to 13. And what this standard does is it gives teeth to those sections. So if you compromise or if you breach any of those rights, that is automatically a breach of the sixth standard, and that opens you up, obviously, to prosecution for a breach of the Act and offenses and which is an offense punishable with fines and penalties, including imprisonment, as mentioned earlier. The seventh standard. The seventh standard indicates that appropriate technical and organizational measures shall be taken against unauthorized or unlawful processing of personal data and against accidental loss or destruction of or damage to personal data. And you should also take these measures to ensure that the Commission is immediately notified of any security breach affecting personal data. This standard seeks to secure the data. So you must make sure once you take people's information that you put in place both the technical as well as the organizational, the processes in your organization that will ensure that people cannot gain access to that data in an unauthorized or unlawful way, or damage it or lose it, etc., etc. And as well to ensure that if there is any breach, you're able to notify the Information Commission immediately. Some of the measures that the Act mentions that can be taken, these are a few: pseudonymization and encryption of personal data, protection of confidentiality, integrity, availability, and resilience of processing systems and services, backup and restoration systems, testing of the effectiveness of existing technical and organizational measures, and any measures necessary to ensure adherence to the DPA's technical and organizational requirements. You can't scrimp on the IT budget. You're now going to have to put in place what is necessary to protect the information. I think most of us are aware that earlier this year, 2 financial institutions in Jamaica suffered breaches to data, suffered data breaches. If the Act were enforced, the question would be whether they'd taken the appropriate technical and organizational measures to protect it against those breaches. And if they had failed to do so, then they would be liable to fines and imprisonment, possibly down to the officers who may be culpable, and as well civil liability. So we are entering into a new sphere. Don't think you can just pass the ball on to whoever you ask to, let's say you outsource your data processing. The Act requires that you ensure that you get sufficient guarantees in respect of those technical and organizational measures from those third-party processors, the data processors, and you must ensure, as the data controller, that you take reasonable steps to ensure compliance. Plus, you must ensure there's a written contract under which the data processor acts only on your instructions. Some businesses have their data in the cloud. That raises questions. Do you have a contract which ensures that they can't deal with that data outside of what you say they must do? The 8th standard. Personal data shall not be transferred to a state or territory outside of Jamaica unless that state or territory ensures an adequate level of protection for the rights of data subjects in relation to the processing of personal data. And this, I think, applies particularly to persons, or I should say institutions, that may either have their IT department overseas at an overseas head office, or may outsource the processing to a third-party overseas data processor. The Act says that you cannot transfer that data outside of Jamaica unless certain conditions are met, including in one instance, the data subject consents to it. And then there's a whole list of exemptions and requirements, etc. And I think this is another place where you will want to get legal advice to ensure that if you are in that situation, that you're not running afoul of the legislation through not understanding the standard that has been imposed. All right. So we're about at the end here, and we have bombarded you with a lot of information, and your head is possibly spinning because you're trying to figure out, where do I begin? Well, this is really a preliminary discussion, and what our aim in this presentation has been to give you the broad picture, which Kelly has done, and then to give you a little bit more of a focused view on what the data protection standards are. And I think that's where we need to start. I think the first thing that you may want to do is to conduct some kind of audit, perhaps a data audit, to ascertain what personal data are you processing. Because maybe you didn't realize that you're processing personal data. You thought, oh, that's for people who are in the IT industry. But in fact, if you are an employer and you're taking people's name and their NIS and their TRN and all sorts of things, then you are processing data. And you'll be surprised at the amount of personal data that you're processing if you are not, in fact, careful. Secondly, you want to do an assessment. Once you figure out what you're processing, how are you doing against its standards in terms of processing that data? How do you get that data? Which are the 7 conditions for you to lawfully process? Can you say, okay, I'm under this condition, and so I can process the data? And you can go through all 8 standards and get a feel for where you are. And then thirdly, I think you ought to seek some assistance. And I think we need to consult both legal and IT experts to help us understand the legal implications. And we also need IT experts to look at our systems to tell us where the weaknesses are and how we can guard against security breaches, etc. And then finally, we need to ascertain what needs to be done to become compliant. We need to figure out where are the gaps that need to be plugged and how we're going to fill them. As I said, the Act has this transitional period, but we don't want to wait until the 2 years are upon us or even the clock starts ticking on it. As I said at the beginning, there is more to the Data Protection Act than meets the eye. Taking off my lawyer cap and putting on my managing partner cap right now, I can tell you that certainly as I think about the implications of it for our business, I realize that there's a lot we have to start thinking through and processes we need to put in place to ensure that we're in compliance. I'm sure the same applies to your business, and so we need to start giving some thought to that at this time. I think this is where we end our presentation, and my understanding is that you're likely to have 1 or 2 questions for us, which we are happy to seek to answer in a concise fashion as possible. Thank you so much for your attention. It really has been great being with you this morning and sharing with you this exploration of the Data Protection Act 2020. Thank you.
Thank you so much, Courtney and Kelly. I can tell you that that was very, very informative. And I noticed that you mentioned that we might have about 2 questions. I believe we'll have far more than 2 questions.
It was an understatement.
I think we'll have far more than 2 questions. It was such an enlightening presentation, expertly delivered, I must say, as well. A lot of food for thought. In fact, having listened, having watched, I am going to treat things differently, think about it differently. In fact, I'm wondering myself how this will affect people like myself who likes to be on social media a lot. I'm constantly on social media. So I'm just wondering how this is going to affect people like me. And I want you to tell me what you think as it relates to data protection and people who are constantly on social media, how this will affect them. And then I'll come to you with another question.
Yeah, well, thank you for that, Janet. And I think that's a good question. As Kelly mentioned earlier, we are online a lot. And I think people do not give enough thought to what information they put out there. I think a simple response to your question about being on social media is the fact that we need to be careful about what information we put out in the public domain. Because if we put information in the public domain, then we can't later say if someone begins to process it that we didn't consent. Because certainly one of the bases on which data controllers will say that they have processed our data lawfully is the fact that we have published it. And so I think that there has to be a growing awareness of the value of information. Knowledge is power. And sometimes we don't even realize, you put a simple photograph out, and we don't even realize that embedded in that digital image is all kinds of information. And so we have to become more aware, I think, going forward. And I think the Act seeks to protect people's rights in that way. It's recognizing that people have rights as far as their personal data is concerned. Is there anything you'd add to that, Kelly?
Yeah, no, I think you covered it in terms of the Act creating a balance between individuals' rights, the information that they put out there, as well as the company's obligations to ensure that that information is kept confidentially.
Thank you. Thank you very, very much, because I never thought about it like that either. So there are some questions on our YouTube page that I would like to ask. This one is coming from Ray. Says, how do you evaluate data protection standard? No, that's number 5. Who determines what, which is no longer than necessary is? I hope you understand that question.
Yeah. So this is the storage limitation standard, and the question is, how do you determine how long you have to keep the data, and or better put in the question, who determines? The Act contemplates that there is going to be some regulation in relation to how long information has got to be kept. And so one can look forward to that direction. I suspect as well different industries will have different standards. And so it depends on what the purpose is and what the practice is in the industry. For example, if you're dealing with matters involving land because of limitation period, you may want to keep certain information for, say, a 12-year period. If it's something related to a contract, it may be 6 years. The banking industry has its own standards as to how long it is required to maintain records in order to deal with the tax authorities. So those kind of circumstances, I think, will dictate. But beyond that, I think the question is, the essential question is, do you need it? And so if you take my shirt size, as I mentioned in the presentation, and I'm no longer coming back to your website for to buy shirts, then you really ought to dispose of it. And so I think there is, on the one hand, we may look to regulations and industry standards, but there's also the common sense question. Do you still need it for the purpose for which it was taken? And if not, where we're going now is we need to dispose of it.
Thank you very much. There's a very, very interesting question that just came in, coming from Braylin. I'm going to say that's how it's pronounced. It says, can I send you emails after you have visited my establishment and you used my free Wi-Fi, which advise you will be sending marketing materials before you logged on? In other words, you're going to people's businesses nowadays and you have to use their Wi-Fi. But and you're buying, you're a customer. But before you get onto that Wi-Fi, you have to give them your email address. How legal is that?
Well,
and can they send you marketing materials after?
Actually, my gym does that.
Or before?
So the thing with direct marketing is, like I said, it's consent. The important thing is this a condition of them getting on the Wi-Fi? So they came into your business to buy a bag of sugar. They're in there buying the bag of sugar, but to get on the free Wi-Fi, they must consent to be able to get these marketing materials. The truth is that if someone has consented to it, and it's informed consent, so at the time that they're consenting, if it's just putting in their email address, they are told at that time that, listen, the personal data is going to be processed in this way. So we will be sending you marketing materials for our products. They need to know the purpose. So the purpose is, of course, to let you know that we have a sale on more sugar. But most importantly, it is the class of persons to whom that information is going to be transferred to. So you, as the store owner, cannot then maybe take it to go to your gym and say, well, hey, this person bought a bag of sugar, so maybe you want to, look at marketing to her. It's important, the concept of consent and whether or not that consent was freely given.
Thank you very, very much. I have a question this one is coming as a personal question. I go to the bank and I use the ATM machine. My ATM card is cloned. However, my financial institution that I bank with has no interest in really going to the courthouse. However, I'm interested in going because this is the second time that I'm being robbed, literally. Can I eventually sue my financial institution for not protecting my data effectively and going to court or not?
That's a very good question, Janet. And I think anecdotally it is said that financial institutions underreport electronic fraud because they are fearful that it will reflect badly on their reputation in the marketplace. But I think this legislation is going to change the way that they can operate. If it were established, for instance, that because they failed to put in place the proper technical and organizational measures to protect your data, which is the however that information is defined, which relates to that card that enables you to do that transaction. And because they did not have the correct or appropriate technical and organizational measures in place, your data is breached, then that is, in fact, a breach of one of the data protection standards. And certainly they would have a duty to notify the Information Commissioner. So they, in a sense, no, they can no longer underreport. But secondly, quite aside from whether the DPP or the Information Commissioner decides that they want to bring proceedings against the bank, you have under Section 69 a right, once you can prove that you've suffered damage or even distress in certain circumstances, to sue the bank to say, listen, I've suffered this loss. I've lost $2 million out of my bank account because of you. And the bank said, but it's not us, it's a crook did it. You will say, well, that's between you and the crook. You have an obligation to protect my personal data. And the court will sort it out between the two of you. So I don't know if it goes as far as you're compelling them to go to court, but certainly now they will have to come a little bit more into the light as far as what is happening in terms of breaches of their security. And certainly you will have now a right, once you've suffered damage and you can prove it, to bring an action against them in respect of your loss. You want to say something?
Thank you. Quite interesting times we're getting into, eh? Then there's a question from our YouTube page from Kayla27, who is asking, would consent be freely given if terms and conditions indicate that by accepting the T&C, the individual consents to sharing contact information with a sister company for the purpose of marketing?
So it would relate. So the important thing here is the business that the sister company carries on. I think I alluded to it in my previous answer. So once it is in your terms and conditions, like I said, stated expressly that this is how the information is going to be used, this is what it's going to be used for, and as I said, the class of persons that it will be transferred to, that is deemed informed consent. Now, the truth is whether or not it is reasonable to have transferred that information. So it would really depend on the type of situation the two companies would be in. Courtney, you have anything?
Yeah. No, I agree with Kelly. I think the question is, can you say, as she pointed out, that it is reasonable to say that we're not going to provide the service unless you allow us to share your data with somebody else? Off the top of my head, that doesn't seem to be a necessary reason for your providing, for your receiving the service. And so what the Act is seeking to do is to prevent data controllers from coercing people to give up their information. Consent means that there is no duress. And so again, we're moving into a new sphere where in the past, data subjects didn't have as much rights. To now, the balance is shifting. So that the individual can say, no, in fact, I don't see why I need to give this information up to you. So off the top of my head, it sounds to me like I'd be hard pressed to find a basis for saying that that is a reasonable basis for extracting that information.
Thank you very much. You have answered that very, very well, because I was a little bit unsure, to be honest with you. But now I've gotten a far better understanding. Thank you. Both did very well on that one. There's a question from HG. Will all organizations be required to have a data protection officer?
So as it relates to a data protection officer, no, not all organizations. Data controllers who process data, if you're a public authority, that's one category. If you process sensitive personal data, which we've kind of gone through the variety of different types of data, as well as if you process data on a large scale. Now, admittedly, the Act does not define what a large scale is. As Courtney mentioned, there will be regulations that come into effect. So I anticipate that there will be some guidance in the regulations or through the Information Commission as to what large-scale data processing is. But those are the categories.
Thank you very much. This one is a very, very interesting question. This person is Ray, and Ray is asking, does the Data Protection Act include any clause re persons recording conversations over the phone and in person, and how that recording can be used? Quite interesting, I would say, particularly for me, who is a journalist.
Well, having read through the Act, there is no specific clause that deals with that scenario that you have just described. However, it would fit within the general description of what processing data is, because it's data, is information, however stored, and so once you are storing information, which is voice content, then that becomes data that is being processed. And so the question would then be, do you have a lawful basis for doing so? And then you go to the 8 standards to figure out whether you're treating with that data in a way, assuming you have a lawful basis, in a way that does not breach the standards. That's how I would answer that question. That is a very, I noticed your comment about journalism, which is a live question in relation to the legislation, whether or not there ought to have been a proper, I would say, exemption in respect of journalism. But I think that debate is one that I have to leave to my journalist friends like you, Janet, to fight with the aid of lawyers on a retainer.
Okay, all right. We're probably going to need your services in a sense. But we have a lot of the journalists now becoming lawyers, so maybe they'll take up the case. There is another nice question from Lancelot Henry, who is asking, how will the Act affect the relationship between data controllers and collection agents, example, NWC and Paymaster, for example?
Right. So and the data controllers, well, NWC and Paymaster would be data controllers themselves. So when he asks how it would affect relationship between data controllers and those entities, I wonder if he's contemplating that they are doing outsourcing of their data processing by using data processors. So let's take the simple case. First of all, it means because those entities process personal data, they're going to have to abide by the 8 data protection standards and by the various provisions of the Act. Additionally, if it is, which I think in this day and age, I don't know those individuals' internal business, but if it is that they're outsourcing their data processing, then, as I mentioned in the presentation, they're going to need to ensure that that third party is acting on their instructions only, and that they are not only acting on their instructions only, they are compliant to the Act, and that the data controller is reasonably compliant. I wonder as well if the question is talking about relationship between NWC and Paymaster, which doesn't really change the scenario. Yeah.
Well, actually, if it is in that scenario, if it is between as it relates to NWC and Paymaster, a data subject isn't a company. A data subject is an individual. Mm-hmm. So I don't believe it would affect the relationship between those two entities.
Yeah. So the question really would be how those entities treat with the information that comes to them. So if you walk into NWC, and you give them certain information to open up your account for them to supply water. And because of a contract they have with Paymaster, they share some information with Paymaster that when you walk into Paymaster to pay your bill, they can transact the transaction. NWC is the data controller and would have a primary obligation to protect your data so that when they deal with Paymaster, they can't say to Paymaster, oh, it's your fault, because there is an obligation for them to ensure there are sufficient guarantees in place between the two of them that Paymaster will only act on their instructions and not take your information and give it to some other bill collector, for example. And so I think that's the Act is really trying to catch all the different parts that are involved in dealing with people's data, which is why you not only have a category called data controllers, but you have a category called data processors as well.
And it is an act that really made to protect us, protect our data. There's another question. This one is coming from Danny. If a customer fails to update information when requested by a company, and company therefore uses old data, would that discharge the company's obligation to keep data up to date? I hope, let me know if you want me to read that question over.
No, I understand the question. The question is if I, as a data subject, fails to update my personal data. Let's say I mentioned one bank sending me emails, is your information current? And I ignore those. And the bank can show that over a year I've been getting these emails. And I've moved 9 months ago and I did not say something. Does the bank have a defense against any proceedings that say that the bank did not keep the data accurate? Actually, what I did want to say during the presentation, and I didn't because of time, there is a specific provision that says that if the bank can demonstrate that the information that it acted on was information provided by the individual, the data subject, and that it did everything reasonable within its power, it acted reasonably, then that's a good defense. So there is an obligation still on our part to ensure that we work with the data controllers and we give them current information if we want them to do our business properly. So I think the act is balanced, and I think it's fair in that respect.
Thank you. Here is another question. If a data controller passes information to a third party where they were obviously got consent to or by the customer, and that third party breaches the act using that data, can a penalty be attributed to the data controller?
So, as it relates to a third party's breach, I imagine that what would happen in this scenario is there is a contractual obligation between the data controller and the data subject. As Courtney said, if someone else is processing data received from the data controller should have some sort of guarantees in place as it relates to how that third party is processing data. So if the question is whether the data subject can sue the third party, I'm not sure if privity of contract would allow that.
Yeah.
Yeah?
I think the relationship would be between as Kelly is alluding, between the data subject, the individual, and the data controller. And the act, as she says, requires the data controller, if they, with consent, pass information on to somebody to process the data, then they have to ensure they have sufficient guarantees that that person is going to only act on the basis of their instructions. If that is breached, then an action against the data controller could result in the data controller bringing an action against the third party if they are a data processor. It may be a different situation if, in fact, they're passing on the information not for that third party to process the data, but I don't know, for some other purpose. That would be an interesting situation because the individual having consented, let's say that they consented because it was something to do with their business. You consent to pass on a TRN to somebody for them to do a transaction, and then they take it and put it up on the internet for other people to use, and there's identity theft. I think that's a different scenario, and one that we'd have to give some thought to, and one on which legal advice could be sought.
Thank you very much. We don't have a lot of time left, so I'm going to ask just one last question. Does the act have any retroactive effect? So if data sharing occurred prior to the passage of the act, would a company have to then get fresh consent?
Yeah. That's an interesting question.
I thought so too.
Yeah. So I think the act comes into operation on a date that the minister will publish by notice in the Gazette after the Governor General signs it. And then there will be, as I mentioned, a 2-year transition period during which everybody can get their house in order. I would say, firstly, that that means it really does not have a retroactive effect, generally speaking. I would point, however, to Section 76.3, which says that personal data that is recorded, information held other than by means which enable the data to be processed automatically or to be structured, and it goes on to describe it, will be exempt until the earliest date when the act comes into force from different ones of the standards. And that section, I think, needs to be studied and to be considered. But as a practical matter, I would say, if you got people's email addresses, for instance, before, and you didn't get them you don't have consent recorded, that if you were asked how you're processing this data without consent, I would suggest that as part of our protocols going forward, we send out emails to our mailing list that asks people to opt in to our mailing list, so that as at the date that the act comes into effect, you can ensure that you're compliant. And many of us would remember receiving emails like this somewhere around 2018 from European companies in relation to GDPR. I think that is a good practice. So I wouldn't simply say, well, it's not retroactive, so whatever has happened is good. I think you have to ensure going forward that you can, from that date, whatever data you're processing, that you can defend it on the basis of the standards that are implemented.
Thank you so much. This has been one of the best partnerships that has been established by the Montego Bay Chamber of Commerce and Industry. And we could not have done any better. Doing it with you at Dunncox, the team there, a group of professionals that are informative. They know exactly what they're talking about, and that we have seen in the last, 3 weeks. Paul Neal, one of our directors at the Montego Bay Chamber of Commerce, has been the leader as it relates to these webinars. And we want to say a special thank you to Paulette. She's also an attorney at Dunncox, and she is the one that put us together. So I want to big her up. Along with the rest of the team, we had a webinar team, by the way, which included our Vice President, Carleen May, Vice President, Damian Monthrop, and Directors, Mary Chambers and Karen Benjamin. So that's the team from the Montego Bay Chamber of Commerce and Industry that put the webinar together, but we could not have done it without that fantastic public relations and marketing team at Dunncox and the information technology team at UWI Western Jamaica campus, and now they're in Kingston at Mona. So Mona and Montego Bay were instrumental in getting all these webinars put together. And I want to just big up Andre Hewitt. Today we have Ishmael with us. We could not have done it with Dr. Patrick Prendergast, campus director. And I know that we're going to be doing far more than we're doing now, but this is a great start to the middle of 2020. By the end of the year, we hope to do another at least 6 webinars to help our members to navigate during COVID 2020. I'm going to allow one of the Dunncox persons to bid us goodbye in their way as well. So I invite any of you from Dunncox to give the parting words.
Thank you, Janet. And certainly it has also been a fruitful partnership for us. It's been our pleasure partnering with the Montego Bay Chamber of Commerce and with UWI Western Jamaica campus. And as you mentioned, we're here at Mona, and they brought them in the loop. We're very grateful for all that's gone on, that's gone into this series of webinars. And we look forward to continued partnership as we seek to serve Jamaica, but in particular in this instance, Western Jamaica, with the talents that we have at Dunncox. Thank you so much. It's been a pleasure being with you on behalf of the Dunncox team.
Our pleasure. Thank you.